Speaking of the United States, U.S. Supreme Court judges have now signaled that they are unlikely to strike down the Affordable Care Act or the Obamacare. The judges heard arguments by a coalition of 20 states, including California and New York, who are opposing the challenge. The legal challenge was initially brought by Texas, including 17 Republican-governed states, and was joined by President Donald Trump's administration. The hearing included 3 judges appointed by Trump, including Brett Kavanaugh. The stance taken by the Republican challengers that the entire law must fall in a single key provision called the individual mandate is deemed unconstitutional. The arguments lasted for 2 hours, in which Chief Justice John Roberts and conservative Judge Brett Kavanaugh indicated skepticism. In 2012, Chief Justice John Roberts had saved Obamacare.
I think it's hard for you to argue that Congress intended the entire act to fall if the mandate were struck down when the same Congress that lowered the penalty to 0 did not even try to repeal the rest of the act. I think, frankly, that they wanted the court to do that, but that's not our job.
I tend to agree with you on that. This is a very straightforward case for severability under our precedents, meaning that we would excise the mandate and leave the rest of the act in place, reading our severability precedents. One of my questions is, do you think that's would have been the right result under the 2010 Act, or did that change in 2017, or how would you assess that?
The newly appointed Supreme Court Judge Amy Coney Barrett was in the spotlight. In the past, Barrett wrote a review in which she criticized the Act and Roberts' 2012 ruling, but did not elaborate on those points. During her confirmation hearings in October, Democrats accused Republicans of approving Barrett's nomination in order to strike down the Affordable Care Act.
Said they were doing.
Why couldn't we say that when Congress zeroed out the tax, it was no longer a tax because it generated no revenue and therefore could no longer be justified on the taxing power, so Congress was presenting it as a mandate which would have to be justified by the Commerce Clause.
Vice President-elect Kamala Harris, who had grilled Amy Coney Barrett during confirmation hearings, weighed in on importance of the Affordable Care Act during a public health emergency. She said every vote for Joe Biden was a statement that health care should be right and not a privilege.
And we all know that if the Affordable Care Act is struck down, communities of color would be hit particularly hard. Black, Asian, Hispanic, and Native American, because they are at a greater risk of pre-existing conditions from asthma to diabetes to lupus. And they are also 3 times as likely to contract COVID-19 and twice as likely to die as others.
The case represents the latest legal attack by Republicans on the law which was passed in 2010 under former U.S. President Barack Obama. Republicans have failed multiple times to repeal Obamacare in the Congress.